January 10th, 2025, Michael Jones was arrested in Harris County, Texas, during a disturbance call at a residential location. Mr. Jones was charged with interference with the duties of a public servant for allegedly refusing to comply with police commands while officers attempted to detain him. The charge carried a potential sentence of up to 6 months in jail and a $2,000 fine. Attorney representing Mr. Jones challenged the probable cause for the arrest, arguing that his client had every legal right to walk away from the situation. On the same day, judge presiding over Harris County Criminal Court held a probable cause hearing to determine if there was sufficient evidence to proceed with the interference charge against Mr. Jones.
Or you got to be careful, because you break something, you're gonna catch another charge. So be careful banging on those windows, because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay? Okay. What happened?
On January 10, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted.
Hold on, let's break down what just happened here, because this police report contains a massive contradiction. The officers claim Michael was refusing to leave and yelling aggressively, but then in the very next sentence, they admit he started walking away the moment they arrived. So which is it? If the homeowner told him to leave and he was actually leaving, how can that be trespassing? And here's where it gets even more interesting. The officers say they announced themselves and then immediately commanded Michael to put his hands behind his back. But announcing you're the police doesn't give you automatic authority to detain someone without reasonable suspicion of a crime. The defense attorney is about to argue that once Michael started walking away, the trespass investigation ended, meaning everything that happened after that moment, including the use of force and the arrest, was unlawful. This is the legal doctrine known as fruit of the poisonous tree, and if the defense wins this argument, the entire case collapses. Think about it. If the initial stop was illegal, then the resisting charge shouldn't even exist. The real question is, did the officers have probable cause to stop Michael in the first place? Drop your thoughts in the comments.
Right?
So,
Yeah. Just losing?
So, Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then...
Right, but then cops get up there.
And then they observed him begin to walk away, and it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and...
Didn't say that.
That was in the complete dims, Your Honor. And then it
says... Do you know about that?
And
yes,
aggressive
Judge,
behavior.
But
okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. I smell marijuana. You look intoxicated, because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on
This is the moment the
if he's
defense
charged
attorney
with
goes on the
interference with a public
offensive,
servant, that
and
doesn't
his
come
argument
until
is
later.
absolutely brilliant. He's pointing out that you have a constitutional right to walk away from a police encounter unless they have reasonable suspicion that you've committed a crime. Michael was doing exactly what the homeowner wanted, leaving the property. But the moment he started walking away, the officers claimed he was intoxicated based on vague observations like slurred speech and pupil size. Here's the problem. They never conducted a field sobriety test, never announced they were investigating public intoxication, and never established reasonable suspicion for the stop. The defense is arguing that the officers invented a reason to detain Michael after he exercised his right to leave. And that's where the fruit of the poisonous tree doctrine comes in. If the initial stop was illegal, everything that followed, including the resisting charge, must be thrown out. The prosecution is trying to argue that the officers were still investigating a trespass. But how do you investigate a trespass when the person is actively leaving the property? The judge is listening carefully, and this case is hanging on a critical legal principle. Can police stop you just because they don't like you walking away?
Until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, we identified ourselves as police, so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey, I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw
So
signs.
the trespass investigation ceases because he's leaving. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating, a trespass, right? I mean, for all intents and purposes, isn't that what it is?
Okay.
The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Yes. Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving. Right? It's like, here, let me come and mess with you more.
That would only.
Right? So it's like adding fuel to a fire.
But they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and he
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't be, it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm going to find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we?
Yeah.
You don't like to wear orange, do you? Be careful where you go. Be careful what you do.
Yes, sir.
Everyone's always out to get you, man. Don't let them.
Yeah.
All right, man. Good luck.
And just like that, the judge ruled no probable cause, and Michael Jones walked out of that courtroom a free man. This case is a masterclass in how constitutional rights actually work in America. The prosecution tried to argue that officers had the right to investigate a trespass and public intoxication, but the defense attorney demolished that argument with one simple fact: Michael was doing exactly what he was told leaving the property. The moment he started walking away, the trespass investigation ended. The officers had no reasonable suspicion, no announced investigation, and no legal grounds to stop him. Without a lawful basis for the initial stop, the entire arrest crumbled under the weight of the fruit of the poisonous tree doctrine. The judge's final words to Michael were a stark reminder. Be careful, man. Everyone's always out to get you. Don't let them. This ruling reinforces a fundamental principle of American law. Police cannot detain you without reasonable suspicion, and walking away from a situation is not a crime. This case should be required viewing for anyone who wants to understand their rights during police encounters. If you found this case as jaw-dropping as we did, smash that like button, drop your opinion in the comments below, and don't forget to subscribe for more explosive courtroom breakdowns just like this one. We're bringing you cases every single week that expose the truth about the justice system, so hit that notification bell and stay tuned for the next battle.